success that we have achieved in Pillar 3, it is a result of the combination of the energies that were brought by the different disciplines coming through with one goal, which is to ensure that we make this NSP to have life and to be experienced by the woman who is walking there on the street. So a lot of work has been done. I mean, within a shortest space of time, we were able to have 6 bills all considered by Parliament during this time. That is starting from May 2020 up to where we are right now. 6 bills were considered by Parliament, and as NSP Pillar 3, we were very active in terms of considering the work that has been done, and also having people who are responsible for the drafting of those bills coming to us to report what is in there and all that, and giving them our inputs and ensuring that they are an encapsulation of the aspirations of the Presidential Summit Declaration. Remember that we have the article, I think it's Article 9, that says that the legislation must be reviewed, and with one goal, which is to make them to be victim-centric, because we have a justice system that cannot work without a survivor. A case prosecution cannot succeed without the evidence of the survivor. So now we have to have a criminal justice system that is responsive to all the different needs of the victim when they come into the system, because when they come into the system, different kinds of fear. There's a fear of the unknown. There's a fear of further retaliation. What if he comes after me? There's a fear of shame as well. There's ambivalence, all right? What if I lose this case? Maybe I don't say the right things, all right? There's also the fear of humiliation. What if when I get there, they ask me questions that will be very intrusive? So we have to have then, if we want to have an effective criminal justice system, it must focus and be very responsive to the needs of the victim. And starting from the entry point up to the exit, it must provide support services to the survivor. As a survivor is journeying through the system, all right, at every service point, because this is a very critical person in the criminal justice system. We cannot succeed without this person. So then we need to invest resources of ensuring that when you are at this stage, what is it that you need, all right? When you are at the courts, what is it that you need, all right? And end up to the end, so that we have a victim at the end of the process who will say that I have not only seen justice being done, I have also felt it, all right? Because it's not a matter of having a conviction, all right? It is all about how did we treat you in the system? How did you make you to feel valued by the system? Because this offense has been created through you, all right, and against you. So we are calling it a crime today because you are there at the center of it. So now we want to clean crime, but we cannot address crime without the person against whom the crime has been committed. So it is all about that. So we put together then these 3 bills that we're looking into there. So I can just mention then a number of issues that as we were considering them, we wanted them to respond to 3 base documents, all right? One, the 24 demands of the hashtag total shutdown. And secondly, the Presidential Summit Declaration that came as a result of the conversation that we had at the first summit, all right? And then thirdly, then the product of the first summit, which is the NSP, the Presidential Summit Declaration, which the NSP is coming in then as an actioning document for the Presidential Summit Declaration. So we look at those three base documents and say that we need then to have pieces of legislation that will be responding to all the demands that women were calling for. So they were saying that we don't want the accused persons to be released on bail. And I would like then, when I get to that point, just to explain a few things. That it is impossible for us, for the courts, to say no bail to any accused person. And the reason for that is because we have a section 35 of the Constitution which gives a plethora of the rights of the suspected, arrested, and accused persons. And all those categories are the categories of the people who are charged with a crime, all right? So it's about criminal procedure, all right? Criminal environment, all right? So when we talk about now the criminal environment, then there is a victim of crime. So the same Constitution has got Section 9 that speaks about equal protection, giving equal protection to the law, of the law to every person, and the equal enjoyment of the benefit of the law. All right. So it is a provision that gives them that protection. What I can say is actually the encapsulation of the principle of equality before the law. But then the same Constitution, it has one provision that speaks to a particular category of people. That is the suspected, the arrested, and the accused, and is mum on the rights of the victim of crime. So for me, that's a serious lacuna that we need then to have urgently so being brought to the attention of Parliament, that it needs to be addressed, all right? Because for as long as the accused person, when the accused person appears before court, is holding the Constitution, which is the supreme law of the country, and the victim of crime is holding the Criminal Procedure Act, all right, that must bow to the Constitution. So there's already an imbalance there. So if we say no bail, the accused person will be saying that you are violating my rights. So the Criminal Procedure Act then must be drafted in a way that will be recognizing the constitutional right of the accused person. But of course, there's a clause in the Constitution about the limitation of the rights. So then the proceedings then that come now into the court space should be looking into that. All right. So the accused still comes and say that I have a right to be released on bail, and it is a constitutional right. So and now, looking into that and speaking against that backdrop, we made an amendment as women were calling and marching in 2018 and saying that no bail. So there are changes that have been made, all right, introduced by the Criminal and Related Matters Amendment Act of 2021. So the first that it says, I'm just going to mention a few of those. The first is to say that no police bail, all right? So when I say no police bail, they will have those instances of a person, all right, I would say maybe charged with a violation of a protection order, and then the next hour is seen walking in the streets. And the reason for that, it is because of the fact that the Criminal Procedure Act has got a provision that is actually allowing police to grant bail, all right, to release that person from the police cells. That is before this person can appear before court, all right. So now we have in this act put a provision that will stop that in cases of domestic violence, in cases that are GBVF related, that all those arrested persons must make their applications before court, so that there is that inquiry that will be including the voice of the victim. So the victim will be there, to articulate the risk factors, that things that, all right, should you take this person out, this might happen, and this is what this person did in the past, is having a firearm, has got this, the family members and all those risk factors need to be considered, all right? So the voice of the victim must be heard during the bail applications, all right? That's the first thing that we've done. And then the second now is to say that now during the bail application in the court, if then the victim is a domestic relationship with the accused person, all right, and they're staying together, so then what we are saying is that the magistrate or the presiding officer, before granting bail, must conduct an inquiry into the history of violence between these two parties, all right? And then secondly, and determine whether there is any protection order that is valid between the two of them, all right? So if the answer is no, there is no protection order that has been granted against the applicant for the bail, all right? So then what this act says is that then the magistrate must not grant bail without the protection order being granted against the same person. So meaning that then we are sort of ensuring that there is that protection, that is afforded to the victim, if then the interest of justice demands that the bail be granted to the accused person. Do you understand what I mean? Mm-hmm. So now there will be those sort of orders that will be like, if the victim says that, I don't want him to be in my house, all right? So the protection order will be issued by the same magistrate, all right, to say that now you are prohibited from living in the same or sharing the same residence or the joint residence with the victim, or you are prohibited from entering a particular space. It might be the bedroom in the same joint residence, depending on what the circumstances are between them. So, but what we are saying is that he must not be granted bail without the protection order. All right. So it's one of those things that we have included in this trying to tighten the provisions for bail. But I would like your audience to know that for as long as Section 35 of the Constitution is not amended to include the rights of the victim of crime, we will continue having this imbalance. when we get to court, because the accused person is holding the Constitution, and the victim of crime is coming through with what? The Victims Charter, that is toothless, that is not enforceable, and is also coming through with a piece of legislation that must pass the constitutionality test, all right, meaning that it must bow to the Constitution. So we really need to fast track, the conversation around us reviewing Section 35 of the Constitution. It should not speak only to the arrested, the accused, and also the suspected. It should also speak to the victim of crime. So it is either two things: that we amend the Constitution by including a separate provision that will be speaking to the rights of the victim of crime, all right, the way that it is, all right, with Section 35, or amend Section 35 and inject in it certain rights that will be speaking to the victim of crime, so as to create that balance, all right, that Section 9 is talking about. Because Section 9 has it's a provision that gives that encapsulation of the principle of equality, all right. So that's the first thing. But the other thing that I would like to talk about is that, as I said, that with Pillar 3, 6 pieces of legislation during this time were passed. That is, first, the Criminal and Related Matters Amendment Act, the one that I'm talking about, that was addressing the issues of bail and all that, and also the issues of sentencing. Remember that women were marching and saying that we want stiffer sentences and so on. So in this act, the Criminal and Related Matters Amendment Act, we also tighten sentences. So, for example, for gang rapists, life imprisonment sentence. For serial rapists, life imprisonment sentence will be imposed. And also for child homicide, life imprisonment sentence. So it's a number of, convictions on particular crimes that now would be visited with life imprisonment sentence, so as to make it tougher for the accused person, not to make it easy for them. And also, it also recognizes a femicide, but of course, with our legislation, we don't say femicide because the Criminal Procedure Act talks about murder. But then we are saying that then if it is about, the death of a person who is within a domestic relationship that amounts to a domestic homicide, then it must be visited by a serious a sentence, which is the ultimate, which is the life imprisonment sentence. So what it means is that then it will fall within then the depend on the bunch and the circumstances of the case, all right? But then this piece of legislation, then it makes that provision. And also then the same piece of legislation, as women were crying and saying that we want a criminal justice system that is disability-centric, all right? That recognizes a sign language and so on. So this piece of legislation, it recognizes that. It says that now we are recognizing demonstrations. It doesn't matter what, because not all of our people go to school to learn sign language, all right? So you have those then that do the sign language in a way that is like in a home environment, because it's not backed up by any education. So we are saying that as a court system, we should not close door for them. It's the way that it's their sign language. So we are saying any kind of demonstration that you have, and including the lip speaking, all right, and all of those, we are saying that now they are considered as viva voce evidence, admissible evidence in court. So they are recognized by this piece of legislation so as to make the criminal proceedings, all right, so as to make the criminal proceedings also to respond to provide reasonable accommodations for witnesses with disabilities. So we have to do that. So it's also that. So with Pillar 3, we did not stop there. We also, the Department of Justice now developed a national strategy for reasonable accommodations, for access to justice by users with disabilities. So it is a strategy then that is looking into the criminal justice system and also looking into the different needs according to the different types of disabilities as to how we could actually provide the reasonable accommodations and have a system that will be speaking to them, addressing their needs as they enter into the court system. So we developed that strategy and developed the minimum standards and looked as well into the changes that the legislation is bringing so as to accommodate the court users with disabilities. And with that then, we upgraded 114 courts in line with the minimum standards. And we also trained then the you know what we actually, it's a progressive thing, all right? So before we can say that this court now we are aligning it to the minimum standards and so on, then we will conduct a training for all the frontline officials, all right, and to sensitize them about the minimum standards, to sensitize them about the reasonable accommodations and all of that, and that particular court establishing a reasonable accommodation coordinator, somebody who's going to be responsible of ensuring that that court stays compliant with the minimum standards. So thus far we've got 114 of them and we're moving on with that. But that's also, you know, a deliverable for Pillar 3. And the other thing that we sort of did for Pillar 3, remember that women were saying that we want the sexual offences courts to be recognized by a piece of legislation. We don't want them to be established by a particular model, all right, which can be phased out at the later stage. So now what we did, we made them to be legislated. Now the sexual offences courts are actually now the statutory courts. So our minister approved regulations relating to sexual offences courts, which actually are an embodiment of you know, the basket or the catalogue of the support services that we must provide to a survivor of sexual offences as they get to court. So we did that. So it's a number of those that we put in. So then 83 of those courts then were converted into that. So now, as I move on, you know, is to also to say that it is also in Pillar 3 that we came up with regulations, all right? Regulations for the NRSO, and also coming up with the amendment of the Criminal Law, Sexual Offences and Related Matters Amendment Act, which is actually where dealing with the NRSO, the National Register for Sex Offenders, where women were saying that, why is this register protecting children and persons with mental disabilities and excluding us as women? So now what we are saying is that all the convicted sex offenders must be registered in a National Register for Sex Offenders. Now we're going to be asking, what will be the consequences of your name or your particulars being included in the register? What means is that you will not be allowed to work in an environment that will give you access first to children, secondly to persons with mental disabilities, persons with physical disabilities, sensory disabilities, intellectual disability, and also where then work in an environment, in a facility that provides services to older persons, that provides services to those categories of persons with disabilities. And also, above all, we are to address the issue of the tertiary institutions where young women will be raped by their lecturers and so on. So we are to ensure that they get that protection as well. So then we are saying that they are also part of the category of vulnerable persons. Now, young women who are below the age of 25 who are in tertiary institutions are protected as well. So what does it mean? It means that lecturers must be vetted against the NRSO. Workers who are there, security guards who are in tertiary institutions must be vetted against the NRSO. And also educators in DBE, all people who are working in the shelters must be vetted. So it's all of those then being vetted. So in pillar 3, we actually succeeded to achieve 55% of our indicators in terms of what we're supposed to be delivering right now. We've got 33 indicators. Out of those 33 indicators, we achieved 21 of them, and we are so proud of the work that we have done. Thank you.